Thank you.
Good morning. Please sit there. All right, as you know, this morning we are going to begin the hearing scheduled to decide on whether to maintain or modify the personal precautionary measures for the defendant, in this case, Mr. Koldo García Izaguirre. For this purpose, the floor is given to the public prosecutor.
Hello, I came, Your Excellency, to request the provisional detention communicated and without bail of Mr. Koldo García Izaguirre. The reason for this request and for the tightening of the measures agreed upon so far is based on the increased rational risk of flight that has arisen. After the issuance of the order for summary proceedings and the consequent indictment by the public prosecutor, this tightening, this situation, this request for imprisonment is clearly not justified. The provisional measure due to the risk of destruction or alteration of the source of evidence or due to repeat offending, which are absolutely not present in this case, the need to prevent this reasonable risk of flight, the factors that establish or the criteria set by Article 503 of the Criminal Procedure Law itself to assess that risk of flight. They are, as we know, the seriousness of the sentence, the imminence of the oral trial, and the family, work, and economic situation of the accused. Certainly, the risk of flight has existed since the beginning of the investigation of this special case about a year ago. It stems from the seriousness of the crimes that were attributed to Koldo García at that time and the sentences corresponding to those crimes, much higher than those established by Article 503 as the minimum threshold to be able to order such imprisonment. That's why the measures established by the investigating judge, the magistrate instructor, were agreed upon, such as withdrawing the passport, prohibition from leaving the national territory, and bi-weekly appearances before the judicial authority. In June, on the occasion of the presentation of a report, in our opinion, devastating, related to the awarding of contracts by the UCO. In the report, which attributed an extraordinarily important role to Koldo García, we did not consider it appropriate or essential to request this aggravation of the measures, that is, his imprisonment, even though, as I said, the evidence of criminal activity had been extraordinarily strengthened. Nor in October, when the prosecutor's office did not request imprisonment, but expressly requested the maintenance of the agreed measures. Despite the new report presented by the UCO on the assets of José Luis Ábalos, the report also covered, and not insignificantly, Koldo García for his prominent role in managing the assets of José Luis Ábalos within the framework of actions that allow Koldo García to be identified or pointed out as the true frontman for José Luis Ábalos, and a faithful follower of instructions both in the area of assets and in allegedly criminal activities. During the time he was Minister of Development, later of Transport, he was the boss of Koldo García, advisor to José Luis Ábalos. But at that recent time, and as I said, despite the increase in those rational indications of criminality, we believed that the exceptional nature of a measure like pre-trial detention should prevail, since, as we all know, pre-trial detention not only significantly or extremely limits the right to freedom of movement and Article 17 of the Constitution, but it also affects the very right to the presumption of innocence, to the extent that imprisonment is being ordered without the prior imposition of a custodial sentence after the corresponding trial, after the corresponding conviction. Holding a trial in which a person's guilt, the guilt of the accused, is declared, and in this way the presumption of innocence is overturned. That requires, as both the Constitutional Court and this Honourable Chamber too have repeatedly stated, a special motivation in the measure agreed upon, a reinforced duty of motivation in order to agree to it in terms that are constitutional. Happens, in the opinion of the prosecutor's office, that this situation has changed, and it has changed significantly. After the issuance of the order for the expedited procedure, in which the crimes are detailed with extreme precision, the actions attributed to Koldo García are described and complemented with a well-founded regulation. Reasoning in which all the circumstantial evidence supporting both the account of events and the legal classification that is later set out or specified in the prosecutor's indictment is expressed. In that step-by-step criminal process in which the evidentiary material, the circumstantial evidence is filtered throughout successive stages in which the requirements for evaluating that evidence become progressively greater. We have reached a point where we are faced with the holding of an oral trial, with the presence of an indictment, of two indictments, and I will refer logically to ours, to that of the prosecutor's office, which leads to the upcoming immediate or very soon holding of the trial, and to the existence already of a statement of charges, an indictment in which the evidence and facts that Koldo García is accused of are precisely established, as well as the penalties being requested. Penalties in the case of Koldo García are very severe, requested by the prosecutor's office, exceeding 19 years. But even if we look at the minimum penalties provided for those crimes, crimes of criminal organization, bribery, 2 counts of influence peddling, disclosure of privileged information, and 1 count of embezzlement, even if we were to consider, as I said, the minimum penalties for all those offenses, we would be talking about 12.5 years in prison. As I said, at the minimum range of those penalties, a minimum range that, in principle, in a proportionality assessment of the imposition of sentences. Given the seriousness of the offenses and the repetition of some of them, it wouldn't really be the most appropriate or suitable option either. But ultimately, as I said, these are crimes punished with sentences that are the subject of specific charges by the public prosecutor. And this accusation is supported. We believe, based on facts, on very strong circumstantial evidence, with indications that have been strengthened as the investigation has progressed, which allow us to make always in provisional terms and based on the circumstantial evidence we have, but they do allow us to make a judgment of viability. Viability of the accusation, extraordinarily positive in the opinion of the prosecutor's office, given, as I said, the consistency of that body of evidence, of that circumstantial support. Let's not forget either, as I mentioned before, that there is another open case in which the awarding of public works is being investigated, and in which the role of Koldo García is also of enormous significance. And when I refer to indications, and I want to make this point clear, I am not talking about, nor is the prosecutor's office talking exclusively about, the position or the statements made or given in this proceeding, in this special case, by the co-defendant Victor Gonzalo de Aldama Delgado. It is legitimate, it is understandable from a position, from a perspective of the right to defense, to discredit on the one hand his testimony and on the other hand to compare or contrast the criminal or precautionary situation of Mr. de Aldama with that of Mr. García Izaguirre. To begin with, we have to clarify that the crimes attributed to Victor de Aldama are fewer in number than those attributed to Koldo García. As for the crime of embezzlement and the 2 crimes of influence peddling, Victor de Aldama has not had the slightest, not even the smallest participation. Crimes, moreover, that in the case of Koldo García, as well as his former boss, José Luis Ábalos. These are crimes committed by public officials which carry greater seriousness. And therefore it is natural and it is totally thank you. With the qualification that the sentences requested for Victor de Aldama are significantly lower, in addition to the concurrence, which seems quite clear, of the analogous mitigating circumstance of confession. Secondly, as I said, Victor de Aldama's testimony can be discredited and challenged, but it should be clarified that the accusation against Koldo García does not hang on Victor de Aldama's testimony. And in any case, this testimony, in the facts that are the subject of the accusation by the prosecutor's office, they are in any case corroborated by other pieces of evidence with significant incriminating power. Therefore, we find ourselves in a new scenario in which there is a written accusation, in which the evidence has been confirmed, has been seen. Thank you. And this is the first aspect in relation to 503 that would justify is that modification of the situation of... Thank you. For the situation of provisional imprisonment that we are now requesting. Secondly, the oral trial extremo oeste is very close to taking place, which is also referred to, as I have said, in Article 503 of the Criminal Procedure Law. So that sentence, besides being foreseeable, also seems imminent. I would like to make a clarification regarding the proximity of the oral trial. I don't think it's relevant or even legitimate to make comparisons with other situations that may occur before other judicial bodies, or even with the position that the prosecutor's office may have taken in other proceedings, especially if we're talking about proceedings before the National Court. Such a comparison may be appropriate to the extent that the special case comes from another case, if you'll pardon the redundancy. From a reasoned statement submitted precisely by a central investigating court of this judicial body. But the timing of the National Court is quite different from that of this Supreme Court. In this year's report from the Anti-Corruption Prosecutor's Office, I specifically refer to the extraordinary delays that occur in the National Court in cases handled by the Anti-Corruption Prosecutor's Office, between the date on which the order to open the oral trial is issued and the date the trial is held. 4, 5, 6, or even up to 8 years can pass before the oral trial is actually held or the hearing takes place. And obviously, imprisonment cannot be ordered to speed up the proceedings or to give preferential treatment to a particular criminal case. In this case, it is not being requested. I repeat, it seems obvious, but I want to make it clear. Imprisonment is not being requested to speed up the proceedings. It's not so that the hearing is sooner, but rather that the proximity is objective based on the calendar that this Supreme Court can manage. An imprisonment is ordered because of the proximity of the trial, and imprisonment is not being requested, or rather, it's not being requested to shorten the timing of that event. I think it's a necessary clarification for the reasons stated. I understand that the agreed measures are the prohibition to leave the country, the withdrawal of the passport, and the required court appearances. They seem clearly insufficient today to prevent a flight risk, which, as I have said, and to summarize, is specified in a request made in an indictment by the prosecutor's office, also by the popular prosecution, and with the imminence and proximity of the trial, all of which, in the opinion of the prosecutor's office, entails an objective increase in the risk of evading justice by the person who is no longer under investigation, but now accused, Koldo García Izaguirre. Thank you. Thank you, Your Excellency, Mr. Prosecutor. The floor is yours, Mr. Counsel, for the popular prosecutions.
Thank you. With your permission, Your Excellency, Mr. Magistrate. This party joins the request of the public prosecutor. Therefore, I also request provisional detention, communicated and without bail, for Mr. Koldo García Izaguirre. Already in the order of October 16th of this year, the Honorable Mr. Magistrate Instructor spoke of a growing risk that still did not seem significant enough to warrant a decision at that time. At that time, the Magistrate Instructor did not consider provisional detention to have the necessary intensity, but he was already announcing the possibility of ordering more severe precautionary measures in the future if the oral trial approached. In this part, the popular accusations that I am honored to represent believe that the future moment foretold by that order of October 16th has arrived. Has an order of transformation already been issued? In the procedure, it has been specified what facts the oral trial will proceed on. Written indictments have been submitted by the public prosecutor and by the popular accusations, requesting significant prison sentences. Therefore, we can no longer talk about a potential existence of crimes or a potential existence of further penalties. Instead, the criminal threat hanging over the accused today is very significant. Referring to the requirements of Article 503 of the Criminal Procedure Law, we understand that it is not necessary to make a special consideration of the first two. We believe it would be enough to refer to the brilliant order transforming the proceedings dated November 3, which contains all the facts that constitute the elements of a crime, as well as the evidence from which the possible responsibility of Mr. Koldo García is derived. The public prosecutor, through his honorable representative, has specified some of this evidence, and we have added some ourselves, especially the telephone conversations from devices seized in the home of the accused. The reports from the UCO, the statements taken, and all the evidence currently weighing against him show Mr. Garcia's involvement in all the events under investigation, alongside the then Minister of Transport, Mr. José Luis Ábalos Meco. We believe that, therefore, the first two requirements are met. We only need to address the third one, that increasing risk already predicted by the order of October 16th. We believe that today it becomes clear in its fullest expression: the requested sentences, the defendant's financial situation, and the imminence of the oral trial. These are the requirements set out in Article 503, and in this case we believe that it has concluded what happens in all of them to justify the measure we are requesting, with the sole need to ensure the defendant's presence in the proceedings, since there is a rational inference of a significant risk of flight. We already referred during the hearing held on October 16th to Mr. Garcia's ties abroad with businesses overseas that have been duly proven in the proceedings. Mr. Garcia, he has made use of a network of contacts in third countries to facilitate various business deals through different entrepreneurs in exchange for significant amounts of money. It cannot be ruled out, therefore, that he continues or will continue to take advantage of that network of contacts to use it today with renewed purposes. We cite for this purpose the contract and the statement of Mr. Manuel Sales Carceller through the company Libero District, contrató a placing public debt in Guinea. Mr. Sales stated this on February 27, 2025. The 107-2023 dated June 6 states that Mr. Garcia Izayuri would have received 20,416.67 euros from this company for this action. It has also recently become known that Mr. Garcia Izayuri would have taken steps in favor of this venture, he stated, even when he no longer held any position in the Ministry of Transport. It is also established in the proceedings that the ASBI Group, through Mr. Manuel Contreras, hired Mr. Garcia Izayuri to open new businesses in Latin America. As Mr. Contreras stated on March 5 before this Honorable Supreme Court, Mr. Garcia Izayuri would have made available his many connections in the Ibero-American world, including Guatemala, Nicaragua, El Salvador, Chile, Colombia, and Ecuador. It is also worth recalling now the operations of his brother, José García Izayuri, in the Dominican Republic, receiving at least 2 payments of dólares estadounidenses, US dollars, 10,000 in cash in that country, with the mediation of Mr. Del Dama, or some passages from the report. 157-2025 from October 3rd from the Central Operations Unit, which states that Mr. Garcia Izayuri shared with Mr. Victor Ábalos the tickets for a flight to Colombia. There are also finally conversations with Mr. Santos Cerdan, in which Mr. Garcia Izayuri stated that he had asked Mr. Ábalos, his son, for the favor through a company in Colombia, and that they were giving him $1,000 a month. Well, in short, the economic and financial dimension of the defendant's actions has been made clear by everyone. Do these indications that we are now describing justify the foreseeable or reasonable existence of a solid risk of flight? Finally, the proximity of the oral trial is more than evident. We are not going to insist on this, which significantly increases, in the opinion of this popular prosecution, the risk that Mr. Garcia Izayuri may be tempted to evade the action of justice. For all these reasons, Mr. President and Your Honor, we request provisional detention, communicated and without end, the trust for Mr. Koldo García. Thank you very much.
Thank you, Counselor. The floor is yours, Counselor, for Mr. Koldo García.
Ma'am, yes, Colabella, Your Honor. Before getting into the substance of the matter, I would like to point out a new development that has occurred these days, just today, and which requires, on the part of this court, the determination of jurisdiction by the Supreme Court, as you well know, because I have communicated this to the Supreme Court requesting a suspension, and I have been granted a postponement of the time. I have just arrived, I am coming right now from the hearing, the National Court, because at the National Court we had a statement where Mr. Victor Daldama testified. And what was it? My surprise was that Victor Daldama's statement concerned not only my client's involvement, but also Mr. Victor Abalos in relation to masks, PCR tests, and COVID tests. This must be related to Article 52 of the Organic Law of the Judiciary, which literally states jurisdictional issues cannot be raised. Jurisdiction between judges and courts that are subordinate to each other. The higher judge or court will, in any case and without further appeal, determine its own jurisdiction, or will give the parties and the public prosecutor a common period of 10 days to decide what is appropriate, will request the proceedings from the lower judge or court, or will send those that it is handling. This article should be related to Article 21 of the Criminal Procedure Law, which states that the Supreme Court cannot establish or promote jurisdiction without any trial. A judge, court, or party may raise them against him. When any judge or court is handling a case that is reserved for the Supreme Court, it shall order, either on its own initiative, at the request of the public prosecutor, or at the request of a party, that all proceedings be suspended and the records be sent within 2 days, so that upon review it may make a proper decision. No appeal may be made against the decision of the Supreme Court. What has happened? There has been a request granted by the Supreme Court, which authorizes the Supreme Court to handle everything related to medical supplies, specifically masks. But it's a broad phrase, medical supplies derived from the COVID pandemic, and it also specifies tests, PCR, and so on, because there's someone with special legal status, and I'm surprised to find that my represented party is being, the accused, who is now on trial, is being judged for the same facts, which are the masks, PCR, and COVID tests. Not only here in this special case, but also in the National Court. Well, I already stated it at the time, in my opinion, in my very humble opinion. It is grounds for annulment of the transformation order the court will decide. But what happened today is different. In this case, it is the National Court that has to stop investigating, because there is someone with parliamentary immunity, which is Mr. Abalos. Because today, during the statement, I had an incident and my computer froze. So I couldn't record everything, literally. But up until my computer froze, Mr. Abalos was mentioned by Mr. Aldama on 10 occasions. That is, in almost 100% of his testimony, in 100% of Mr. Aldama's testimony, it was said that my client's involvement, along with Mr. Abalos's, was crucial for the COVID test, for the masks in the Canary Islands. And besides, he talked about several things, about appreciating the Minister of Labor. Did Angel Victor Torres ask for a position in exchange? Well, I mean, a person with parliamentary immunity is being tried for the same facts, and that can't be allowed as a preliminary matter. I request the Supreme Court, the Honorable Sir, to establish jurisdiction. In order to establish jurisdiction, the National Court must refrain from continuing to hear the case. About the masks, well, not just the masks, about everything related to medical supplies from the COVID-19 pandemic. Because by order of Congress, the Supreme Court has a request for authorization, and the continuity of the case is broken. And why do I say that the continuity of the case is broken? His Excellency, in a ruling dated November 5, 2024, said, and I quote, "I know it's not necessary because you were the one who issued it, but for the sake of clarity," I quote, "the commission of criminal acts by a group of identified individuals who are taking advantage of the emergency situation caused by the COVID pandemic is being investigated. In matters related to the urgent and emergency acquisition of medical supplies, masks, special suits, and laboratories to identify traces of the disease." End quote. And this is the order from November 5, 2024. Exactly the same thing we've been talking about today. The purpose of Mr. Daldama's statement in the National Court. There are two ways to look at it. Either there is a non bis in idem because the same identical facts are being investigated, with the same people involved, the same complainant, the same defendants, the same time period, the same identical facts. Well, that can't be. It can be approached from the non-bis in idem perspective, or, as became clear to me this morning, since the purpose of Mr. Daldama's statement, especially Mr. Abalos, look, sir, that can't be. There is a constitutional mandate, there is a request for waiver of immunity, and the Supreme Court has to determine jurisdiction. Jurisdiction must follow the November 5, 2024 order, which already determined it. If someone with parliamentary immunity is involved, the National Court cannot investigate. It's not just because I go crazy going back and forth and I'm the same person, everything has to be in order. The Supreme Court has to have the possibility to compare whether Mr. Daldama's statements regarding Mr. Abalos and my client are consistent or not. Are they? Because, by the way, today he said something he had never said before. Each time always based on evidence that we still haven't seen or provided. But that will have to be settled in a single trial, and with all due respect, the jurisdiction belongs to the Supreme Court as a preliminary matter. Therefore, I only request, so that the continuity of the case is not broken, that the Supreme Court, through the Honorable Magistrate, rule on this. In that case, what is my humble opinion? Does the order of transformation have to be annulled? We need to have the opportunity to hear what Mr. Daldama said in the National Court, to see if he corrects himself or gives the 16th version of what he has said. Because we heard him on the podcast in the National Court twice here, well, each time it's different, something different.
Your Honor, Mrs. Betrayda, is the issue you raised sufficiently clarified? Okay, but of course it doesn't make sense for you to comment on a testimony that none of us present have heard.
It's not. The key is, it's the foundation of the accusation, the evidence, and the popular prosecution.
I'm not saying you can't raise that issue. You've already raised it. You've argued it.
Okay, fine.
But to comment now on the content of Mr. Daldama's statement...
Well, okay, fine. Just a sentence I'd like to add. Has the case been limited only to masks? In this procedure, we have limited ourselves to masks, while in Central Investigative Court number 2, the case is also about PCR tests and other medical supplies. In my opinion, it is included in the request, and since it is the main subject of Mr. Abalos' investigation, it should be here. Therefore, the unity of the case is artificially broken, causing defenselessness, and furthermore, going against what was ordered in the ruling of November 5, 2024, this chamber. So to me, it seems that the situation is more than clear.
I'm going to ask you that when you finish, which I hope will be immediately. The preliminary issue, because I think you've already presented all your arguments, or do you have more arguments regarding the preliminary issue?
No, regarding the preliminary issue, no, but it's a public and well-known fact. And also, yes.
But I won't repeat it.
That came out today. I mean, is it a fact that you hadn't taken into account in the previous proceedings?
Should you listen to me without interrupting me? Have you already raised the preliminary issue? Then, to guarantee your right to defense, I am going to interrupt your statement, so that the public prosecutor and the popular associations can comment on this. And then, once they have commented, I will give you the floor again, so that you can address the matters concerning today's hearing.
Thank you very much.
Well, the floor is yours, the Honorable Prosecutor Alonso, with the Court's permission.
Honorable Sir, we have to disagree with the argument made by the defense of Mr. Koldo García. The delimitation of procedures is established in the order already issued by the Second Chamber, not by this investigating magistrate, but by the admission chamber. When it is admitted, when the reasoned statement submitted by Central Investigating Court number 2 is admitted. I think it's been very clear from the beginning, I don't have the order in front of me, nor do I know it by heart. But it has been duly recalled later on in successive rulings issued by the investigating judge and also by the appeals chamber. The purpose of this proceeding, or of piece 1 of the main piece, which is called the masks case, it refers to the procurement of masks, medical supplies, and any other contracts within the scope of the Ministry of Public Works, later the Ministry of Transport, in matters concerning José Luis Abalos. Today's statements at the National Court by Mr. de Aldama, which I did not attend, but they mainly refer to some files in the Canary Islands. And they mention a new report from the UCO regarding the purchase of medical supplies. First masks and then COVID tests by the Health Department of the Canary Islands. the events related to the acquisition of medical supplies, masks or other types, both in the State Secretariat for Security, the Ministry of the Interior in the month of April, as well as those in April and May. First in the Canary community and then in the Balearic Islands, they have been outside the scope of this procedure from the beginning. The purpose of this procedure is the relationship, the awarding of contracts for construction, masks, any material. During the period when José Luis Ábalos was in charge of the Ministry of Development from 2018 until 2021, June 2018, July 2021, July 12, 2021, all these facts appear to be disconnected from the present case, but not just now, since the very beginning. And as I said, it's something that the investigating judge has repeated endlessly to the point of exhaustion. If in these events or in these contracts in the Canary Islands, in the Balearic Islands, if evidence appears in the Ministry of the Interior, which until now did not exist, of the involvement of Mr. Ábalos or any other person with parliamentary immunity, the Central Investigating Court, if it considers them sufficient to submit a reasoned report to the Second Chamber, will do so, just as it did in the initial case that was being handled in the Central Investigating Court. With the acquisitions or the contracting of management solutions on March 21 and March 27 of the year 2021, it must necessarily be the head of the Central Investigating Court at the request of the public prosecutor or ex officio who makes the assessment. If those indications or those statements that I am unaware of from Mr. de Aldama about the involvement of José Luis Ábalos in those events, which I insist are outside the scope of this procedure, sufficient enough to submit a reasoned statement to the Supreme Court, a reasoned statement that I understand would also not be added to this procedure. In any case, as far as I know, what has been said and what is known about the contracting both in the Balearic Islands and in the Canary Islands. The involvement of Mr. Koldo García or the involvement of José Luis Ábalos does not have a direct connection with the facts under investigation in this procedure. Although it is true that the momentum from that first contract in the Ministry of Transport led to management solutions based on that initial contract having the doors open. Let's say, if I may use this expression, to be able to access other contracts in other institutions, in other public administrations or in other ministries. I understand that this has no relation to this procedure. It does not break the continuity of the case. And of course, we cannot talk about vis in idem in terms of either objective or subjective identity. And because ultimately the eventual ruling issued in this procedure will determine the appropriate consequences in relation to the facts that have been addressed in other proceedings, in such a way that there is no double sanction for the same facts against the same people. There is no risk, as of today, that this will happen, and therefore we understand that this preliminary issue that has been raised should be dismissed. Thank you.
Thank you, Mr. Prosecutor. Does the attorney for the popular prosecution have the floor?
Thank you. With your permission, Your Excellency. Very briefly, of course, I agree with what the distinguished representative of the Public Prosecutor's Office has just stated. I understood there were two issues, the request for parliamentary immunity and this morning's events at the National Court. Two completely different things, but that in the end would lead to the trial of my distinguished colleague. To raise here a question of jurisdiction that seems completely untimely to me. I don't understand what it has to do with what happened. Thank you. With whether this court has lost or gained more jurisdiction or has to give up jurisdiction in favor of the National Court, I don't understand what has happened. I was also summoned to the National Court and I sent a substitute, a distinguished colleague who, in short, didn't raise any doubts or problems for me about this. Mr. Ismael Moreno will review Mr. Aldama's statements at the appropriate time. In any case, it seems untimely to me that this issue of jurisdiction is being raised when my distinguished colleague is perfectly aware of it. What is the delimitation that has been made so far in repeated records of this burial, Your Honor, to whom I am addressing, and the appeals chamber? What are the objective and subjective limits of this proceeding's subject matter? In case there is any doubt, we have a very recent order from November 3rd where the facts being judged here are clearly and precisely defined. Therefore, it is untimely. It is surprising that this is being raised at this moment. It should have been raised, I believe, in writing. I don't know what the request for waiver has to do with any of this. I understand that Mr. Ábalos' legal team must address any issues regarding the waiver request and possible charges against him. I don't understand why it has to be brought up now. On the other hand, I must say that this hearing was scheduled quite some time ago. No appeals have been filed, nor has any issue of jurisdiction been raised in writing. The National Court's statement scheduled for today was long planned, and no written appeal has been filed. But therefore, to do it here now, in my opinion, is absolutely surprising. And regarding the statement from the National Court, I repeat that I don't know what Mr. Andama may have said, but it should not affect the self-transformation that has already been defined. The facts that are going to be judged so far, and of course there will not be a double trial, we are sure of that. I request that we proceed with the hearing without additional procedures.
Thank you very much. Thank you, Mr. Attorney, Ms. Attorney. Now that the claims have been presented, the parties regarding that point you have raised. Now you have the floor regarding the purpose of today's hearing.
Yes, if you allow me, Your Honor, I will answer briefly now.
A reason I'm sure you'll understand. You have presented your view of the matter, and the opposing parties have presented theirs. If you now qualify the opposing parties' statements in a rebuttal, they'd also need a chance to respond, and this could go on endlessly. Your position is clear enough. Do not interrupt me. I am telling you for the last time. The position of the accusations is clear enough. Did you also just hear it? And now you have the floor for the purpose of today's hearing. Thank you.
Well, thank you very much. I will have to hold back from making the clarifications that my colleagues don't know, because they haven't been there, so they don't know what happened. Provisional detention is being requested for my client mainly due to the risk of flight. Well, and it's not believable. There's no one in the world who could believe that my client could escape. Why was he notified 7 days ago? If he had wanted to leave, he would have left 7 days ago, or 6, or 5, or 4, or 3, or yesterday, but he hasn't left. Why? Because he is scrupulously complying with the personal measures, the precautionary measures that have been imposed on him precisely to prevent the risk of flight. Besides, he has a little daughter who is 5 years old, Erica. Where is he going to go? Leaving would mean that he would stop seeing his little daughter, who is the most important thing to him. He would also stop seeing his mother, who lives in the same town as him, which is Benidorm, and his siblings, who also live with him. Except for one, if I'm not mistaken, his whole family, his wife, his daughter, his mother, and his siblings, except for one, live in Benidorm. Where would he go with him? I'm also going to try to respond to the popular prosecution, because they base the risk of flight on things that are even more unbelievable. They say it's because he has businesses abroad. What businesses? What businesses does he have abroad? None. Allow me to tell you that I belong to a firm that has offices in other countries. This gentleman absolutely does not look like he has, anything abroad. But also the work of the UCO has been more than thorough. We have reports that are 500 pages long, all of them. He has been investigated down to the last hair on his head, and absolutely nothing has been found. Abroad, the risk of flight is not credible. Tell me that you are requesting imprisonment for any other reason, but not because of the risk of flight. No, because it's not believable. They say that it is?
If you don't mind, address me, don't address.
Are they the ones who said it? I understand that you are not going to believe it.
No, but do you know the reasonable tradition that the parties address the court, not each other?
Yes, excuse me, Your Honor. It's true that I'm more used to lower courts than the Supreme Court, and there we do address each other directly. Your Excellency, it was noted here that Mr. Manel Sales received it.
There's a button there. No, it's just that you hit the button on the microphone with your papers.
Sorry. Yes, sorry. It has also been said as a reason for risk of flight that he has received from Mr. Manel Sales 20,416 from the company Instalibero district, and that it was for a trip to Guinea. At the very least, we can call that misleading. Why is the company Instalibero district currently in bankruptcy proceedings? He was paid those 20,400 euros that my client received for being on the payroll for 6 months after he left the ministry. because this gentleman looked for a job and this company hired him and paid him a salary that was less than 2,000 euros a month. Well, in total gross, 20,000, 4,000, 16 euros. The trip to Guinea and the business in Guinea that was attempted did not happen. In fact, in the end, it turned into a pleasure trip that has appeared in all the media with certain people and certain ladies. It had absolutely nothing to do with any business, and if the purpose of it had been to do business, the truth is that it didn't work out. And besides, Mr. Manuel Sales has already formally announced that he is withdrawing from this operation, that he was not going to go to Guinea, and in fact he never went to Guinea. And the deal didn't happen, so what did I get paid by Manuel Sales as an employee for 6 months after I stopped being the minister's advisor? Is it true that a deal was made in Guinea? It's not true. And that's what Mr. Manuel Sales has said about Colombia, that he has business in Colombia through Mr. Manuel Sales, which is also absolutely untrue. Anyway, if the risk of flight was because through Manuel Sales he could do some business abroad, you should know, Your Honor, that it is public and well known, because it is registered. The extinction of legal personality. Mercantile Registry in Stalibero District has undergone a voluntary bankruptcy proceeding. As of today, the company is extinguished, dissolved, and published as appropriate in the bankruptcy bulletin and the extinction in the public mercantile registry. Therefore, the suspicions that you can go to Colombia or Guinea with Mr. Manuel Sales or with the company in Stalibero District are completely unrealistic. It has also been said that ADVI appears that it can do new business in Latin America, and Guatemala, Chile, Ecuador have been mentioned here. Which ones? Also, again, my colleague, with all due respect, is confusing one thing with another. Everything related to ADVI is because Patricia had the possibility. She applied for a job at a hotel in Venedo. Nothing to do with business, and that's clear in the multiple WhatsApp messages about whether Patricia was going to work or not. But anyway, ADVI, as of today, Patricia is working at ADVI, right? The job position was to be in Venedor for a hotel, which also hasn't happened, and it has nothing to do with Guatemala or Chile or Ecuador. We don't know, with all due respect, where the popular accusation came from. As for being able to go with her brother Joseba to the Dominican Republic, her brother Joseba lives in Venedor. He is a neighbor of Mr. Koldo García. They are very close. They live together. Both of them take care of their mother, who has been widowed for 2 years. If I recall, for 2 or 3 years, both Mr. Joseba García and Mr. Koldo García have shared the responsibility. The care of their elderly mother, who, by the way, if he runs away, he won't be able to take care of his mother. He has very strong family ties in Benidorm, Spain, which have been proven. Even so, he still has a 5-year-old daughter who needs him even more than his mother, an 86-year-old widow. Joseba's connection to the Dominican Republic is that he once had a girlfriend there. By the way, that girlfriend is still with him to this day, so that's the possible connection Joseba could have with the Dominican Republic. He left with that lady because she currently lives in Europe, so this is also easily provable if necessary. It is said that in the police report from October 3rd, 2025, there was a flight to Colombia, and that Abalos' son was receiving 1,000 euros a month. What does Abalos' son have to do with this gentleman? If the gentleman, Abalos' son, receives or does not receive 1,000 euros from a company in Colombia, I don't know. I don't think it's true, because in Abalos' asset report it was noted that he might continue, but the popular accusation omits. I think that consciously and with all due respect, the conclusion that in the end it wasn't done either, but in the hypothetical case that it were true, that Abalos' son has connections in Colombia. My client doesn't have them. My client has a mother, a daughter, a wife, and some siblings living here. And he also has a pension. He has a disability due to a problem he had with his foot some time ago, a disability. My client's income comes from a pension. If he leaves Spain, it will be seized. Well, as of today, his accounts are monitored. He receives a monthly allowance, which he wouldn't receive if he left Spain. If he doesn't receive it, his daughter wouldn't get the child support and so on. We're back again to the fact that it's materially impossible for my client to even consider leaving Spain. He wouldn't have any income, he wouldn't have anywhere to go or anyone to go with. And besides, he would be leaving behind his daughter, his mother, his brother, and everyone else who in one way or another depends on him. His daughter financially depends on his disability or incapacity pension. Right now I can't remember, but he receives it monthly, and that's what his daughter lives on today. His ex-wife too, his wife Patricia, also lives off that, and his mother lives off the assistance. So if this man doesn't take her out, his mother doesn't go out for a walk, I mean, the risk of escape is incredible. Absolutely, absolutely, we are at the Supreme Court. For me, I have many flaws, and I do things and it's obvious that I'm used to a different kind of court, more like investigative courts or the national court. Of course I am. For me, the Supreme Court is the highest guarantor of procedural guarantees. It's the one that sets the law. We learned in law school that the law doesn't say what it says. The law says what the Supreme Court says, which is right. The presumption of innocence is safeguarded by the Supreme Court, and the risk of flight must be interpreted and assessed by the Supreme Court. And whatever the Supreme Court does will have an impact on absolutely all proceedings. For me, it's an honor to be here, because I'm experiencing firsthand what it's like to be in a courtroom like this, with courts, with judges. I'm honored to defend Mr. Koldo García Izaguirre, especially for the chance to appear before the Supreme Court. But of course, I come here with a blind faith that the Supreme Court is the highest guarantor of the presumption of innocence and constitutional rights. Just as I believe in the issue raised at the beginning, and that we are not going to be divided here over masks and IPCRS, I believe that too. I also believe that it will succeed, because otherwise we would be facing a terrible precedent. I mean, it would open the door to this. It's a media trial, so society, since some audios of some women have come out, is demanding that this man be in prison. No, the law is something else, we studied something else, and a flight risk is a flight risk. And this man has gone on the 1st and 15th of every month since it was imposed to sign in. His passport has been taken away, and there hasn't been any new development except for a written accusation. Here we are, and more will come. The one from Public Works will come, those from the National Court. Here we are. He always comes when called, never making excuses. I requested the suspension today because I heard on TV that Aldama would give evidence and thought I might not have enough time. I've had plenty of time because he hasn't presented any evidence, and I even had extra time to come. But let's see, what risk of flight? The argument given by the public prosecutor, with all due respect, is not credible. Nothing has changed, nothing has happened. And the fact that now there is an order to initiate the summary proceedings, it's logical, the process is moving forward. Now it's just closer. The trial, yes, but has this gentleman given any sign, any indication that he is going to flee? None. And the subsequent procedural events cannot be considered a flight risk. That's not a flight risk. That just means that justice has taken its course, that the investigation phase has ended only because of the masks. Allow me to remind you that regarding PCR suits, the case against those from the Ministry of Transport is still ongoing at the National Court. And nothing else has happened here. That's not something new. It makes us think that this man is going to be able to leave his 5-year-old daughter without food, or not take his mother out for a walk.
Mr. Aritrada has already said this. I would appreciate it if you could be brief.
Yes, I wanted to go over my notes a bit. I wouldn't like, considering the interests at stake, to leave something out. Listen to me for a second.
Listen, you're not listening. There's no rush. If you need to review your notes, go ahead. I just ask that you don't repeat arguments.
That's just my style, sir.
You've already said this. Just telling me once is enough. I understand. And the attorney and the honorable prosecutor, if we understand it the first time, then don't repeat arguments.
All right, yes.
Take a moment to consult your notes. Use it.
Well, we've been told that the evidence, that there's a risk of flight, that there's a judgment on the viability of the action. The public prosecutor has said that now, after the order to initiate the expedited procedure, there is a judgment on the viability of the action. And why? He says, because Mr. Aldama, who has fewer charges, not embezzlement, has a statement, a strong one, and also with a confession that could be a mitigating factor. Well, that happened here, because today the National Court, regarding the Ministry of Transport and the masks, has said something else.
But the thing is, we're here.
This is a new fact. It's a new fact, surprising.
Interrupts me like no one else. We know what Mr. Aldama has said in the National Court, so when we know whatever Mr. Aldama may have said in the National Court will be evaluated in whatever sense. But right now we are talking about today's appearance, so I ask you to wrap up and stick to this subject.
All right. Well, I think it's a good solution to wait and see what Mr. Aldama has said. And if it's true that he mentioned the 10,000 euros a month, which is supposed to be the clue here for the masks, if it's true that those same 10,000 euros a month were used to pay Mr. Abalos to bring PCRs and masks to the Canary Islands or not, if it's true that those 10,000 euros he said he gave here every month, which he mentioned today, were used to pay for COVID tests in the Canary Islands and that he paid them to Mr. Abalos, is it true or not? I think that's a very good solution. Let's wait and see what he says so you can check Mr. Aldama's statements yourself. And if it's true that the continuity of the case was broken, because there's something very clear in Article 21 of the Criminal Procedure Law,
Regarding the preliminary issue you raised, there is no longer any possibility for arguments. I've already explained this to you. You and the parties made your arguments. That issue is now closed and will be resolved accordingly. Now we are talking about the appearance, and I insist, please wrap it up. We can wait if you have any new arguments, but not for you to repeat what you've already told us.
That's enough. Please give me 15 seconds to repeat.
It's not a matter of the number of seconds. It's a matter of you taking the time you need, if you need more, to present any new fact or any new situation. And if you want to do it, go ahead. And if not, then just finish your report. That's the point, but don't repeat unnecessarily.
I don't think you've left me anything, nothing else, no? Regarding the risk of flight, I believe I have sufficiently proven that my client is not going to flee. He is not going to flee. And that's why, yes, I'm concluding.
No, Counselor, it's not about concluding in one way or another. Yes.
But I need to finish my report.
Yes, Counselor, please specify any new fact. You claim that there is no risk of flight. Do you think I don't understand what that means?
No, excuse me.
I understand what it means. So there's no need for you to repeat it 4 times, even the first time. I already understand what you mean. I'm a normal person, okay? I understand the first time what you mean. Please continue, but finish your report.
No, I was just giving my final concluding sentence of the report, because I've already been able to go over my notes. I believe I have addressed all arguments from the public prosecutor and private prosecution regarding the lack of flight risk. I maintain and insist that there is no risk of flight, and I am sure that you, Your Excellency, know that this is the case, that there is no risk of flight. And with this, I conclude my report. Very well.
Thank you, Mr. Koldo García Izaguirre. Would you like to add anything your lawyer hasn't mentioned?
Well, I ask you to understand a little that we all have the right to learn day by day and little by little. And the only thing I can tell you, Your Honor, sir, is that I'm not going anywhere.
Anything else?
No, sir.
Very well. The proceeding is over. You may leave, but you must remain in the building until you are notified of the decision that will be made. Yes.
Sir, thank you.